Keep up to date everywhere. News Talk 820 WBAP.
In the WBAP newsroom.
Welcome back, my friends. You found the Chris Salcedo Show here on News Talk 820 WBAP. This is where we dismantle liberal ideology one issue at a time. Let me read from the account, if I can, of ABC News. Less than 2 hours after a federal judge in Hawaii issued nationwide temporary restraining order on Donald Trump administration's revised travel ban, the president slammed the decision as an unprecedented judicial overreach. I can't say that I blame him. I can't say that I blame him at all. Let's talk more about this with our guest, one of our legal eagles here on the Chris Salcedo Show, Byron Henry, appellate law expert with the law firm Scheef and Stone, L.L.P. in Dallas, Texas. Mr. Henry, welcome back to the Salcedo Show.
I'm glad to be with you, Chris.
This order that was issued by this Obama appointee out in Hawaii, he arrived at this conclusion that it was a Muslim ban. And my simple question to you is, how can Judge Derek Watson, again, a left-wing extremist appointee from Barack Obama, here's what he said, quote, a reasonable objective observer would conclude that the ban was issued with a purpose to disfavor a particular religion. Where in the executive order, as written, does that come into play?
It in fact does not appear in the executive order anywhere. It didn't appear in the first executive order, nor does it appear in the second executive order. And this judge has, I thought the reasoning in the first executive order opinion and the Ninth Circuit's opinion was thin, but I kind of gave the courts a little bit of a break in some of my commentary because there was a couple of ambiguities in that first executive order that kind of lumped in some people with green cards and lawful permanent residents. I think we talked about that. But this new order does not mention Muslims. It does not mention religion. It is 6 out of the 7 countries that have been designated by prior administrations as countries with a specific concern with respect to exporting terrorism. For a court to actually look at campaign statements from a citizen and a candidate and to apply press releases and comments made by surrogates on CBS, on Face the Nation and other news shows, to say that somehow now becomes the policy of the country going forward when you take action against any country that is, predominantly Muslim or known for a Muslim population, is unprecedented. And I don't usually agree with Donald Trump's legal analysis. I must say he's not a lawyer. He has good lawyers. But in this case, I must agree that I am at a loss to find any precedent whatsoever for taking a candidate's statements about something he thinks might be a good idea and applying it to a completely different policy that bears no resemblance to what the candidate said he might consider if he became president.
There's a lot to unpack here. So I can imagine, because I'm sitting here ready to scream at the top of my lungs, and I imagine everybody listening to our voice right now, ready to do the same, that they're asking themselves, how can a judge do so much what he's not supposed to do, which is consider campaign rhetoric over what is before him and the legality of what is before him in an executive order, because it is subject to judicial review. How is this judge able to get away with it, and how can this judge be punished by the American people for what many legal analysts are saying is something that he has gone beyond his scope, beyond his purview to do? He deserves to be punished. In my view, he deserves to be thrown off the bench. What recourse do we, the people, have to push back on what many label judicial tyranny?
Well, the answer to your first question about how can a judge do this is, as we know, Article III judges have arrogated themselves, both through the Supreme Court and other courts, an extreme amount of authority and power to basically be the sole arbiter of constitutionality of laws and of executive orders and other government actions in this country. That's not in the Constitution, but we as a citizenry have accepted it. The way the Supreme Court has handled that power is basically to say that on close calls regarding national security or areas where the Constitution gives it to another branch, like immigration immigration, where Congress has plenary authority over immigration and they have given discretion to the president, we basically step back and say the president's power is at its zenith and we defer. It's called deference to the political branches, especially the commander-in-chief. And the problem here is that all the precedent in every court I'm aware of calls for a very light touch by the judiciary and a lot of deference to the president. Instead, what we're getting is no deference to the president, no deference to his authority, no deference to the actual stated reasons for his order, and we're getting basically a sledgehammer, requiring the government to prove every jot and tittle of every national security reason for all these orders, which has never been the standard, and it's basically imperiling national security, where most courts would say Article III judges have little or no a place weighing in on at all, let alone basically declaring entire executive orders unconstitutional when it might affect a few people, literally a few people that may want to come to this country that may not be able to get in for 90 days, by the way. It's just temporary, is extraordinary to me. And the recourse is simply, there's only one recourse for federal judges. You can either punish them within the judicial branch by taking away cases, and judges have to do that, or for the political branches, impeachment is the only answer. So all you can do is follow the process and hope that a higher court will come down hard and sternly on judges that expand the scope of the federal judiciary's power vis-a-vis the executive branch in Congress.
Right, and many citizens feel frustrated that there is no check on this seeming limitless power these judges have taken upon themselves. Byron Henry is an appellate law expert with the law firm Scheef and Stone in Dallas, Texas. Let me ask you this. And I don't want you to opinion. Let me give you my opinion, then I'll ask you to weigh in. This judge is a rather stupid man. This judge doesn't have the brains God gave a soda biscuit, because he has concluded that this is a Muslim ban when 42 countries that are majority Muslims are not affected by this ban. But he has said these 7 constitute a Muslim ban. Do you know how he derived at this? Like I said, my opinion is he's a stupid man and doesn't have the brains God gave a soda biscuit. But you give me the legal analysis of how he came to this conclusion.
Well, the government's argument is of course this isn't a Muslim ban because Muslims are free to travel to this country en masse across the country, except for any citizen, Muslim or otherwise, from these few countries for 90 days. And by the way, there's some talk in the opinion, but there's also a waiver process. While those that are affected by the travel ban can apply for a visa and ask for a waiver from the consular office. So these people that have standing to bring these suits, the courts aren't even waiting to see if they're denied a visa or denied entry to the country. They're saying because there's a possibility they might be denied under this order, we're going to restrain or enjoin the entire process. But the judge is right about one thing. You don't have to discriminate against all persons in a group to discriminate against that group. But what the judge misses is the order has to discriminate against someone in that group. The order itself does not discriminate on the basis of religion whatsoever. If you are a Christian or a Jew living in Iran or living in Syria, you are temporarily prohibited from traveling to this country for 90 days. So this is not in any way, shape, or form a ban or a prohibition on Muslims. And to say that it is basically to say that any time this president, based on his prior statements, takes any action in favor of a country that's predominantly another religion, like, for instance, Israel, that's predominantly Jewish, or takes any action against a Muslim country, whether it's military action, sanctions, refusing to see their ambassador, sending their ambassador home, this judge is saying a liberal organization or an individual could come and sue and force the president to interact with a country because he is treating a predominantly Muslim country unconstitutionally because they're Muslim. And that is not only absurd, but it's extraordinary to think that a federal court can dictate how our president interacts with countries just because their population may be predominantly Christian or Jewish or Muslim. It does not fly under logic or any constitutional authority or precedent that I'm aware of.
Yeah, and we're running out of time, and I can't even get to you about this idea that the courts have no purview over national security. Well, another time, I guess, because this is not going to be the last time an activist judge acts up. Byron Henry, everybody, appellate law expert with the law firm Scheef and Stone in Dallas, Texas. Sir, I appreciate your time as always here on the South State Show.
My pleasure.
All right, more to come, folks.